Meeting to order. La session est ouverte. Bienvenue tout le monde.
Meeting is underway.
Standing Committee on Justice and Human Rights. Pursuant to Order 108, Sub 2, and to Subsection 4, Subparagraph 4 of the Director of Public Prosecutions Act, the committee is beginning its study on the proposition of nomination of Mr. Georges Dolhaj to the position of Director of Public Prosecution. Good morning to you and bienvenue. But before we commence, a number of normal reminders for everyone. For those in the room, again, reminder to prevent disruptive behavior, and potentially harmful audio feedback. You have all the earpieces, so please ensure that they are totally away from the microphone, whether you're speaking or not, but obviously if you're speaking. If you are using them, and if you're not using them, please keep them unplugged. So these measures are in place so that we can conduct our business without interruption. Given this morning's proceeding, we only have one witness. As long as I believe the chair has showed you the use of the equipment, so that's fabulous, that's great, and in the interpretation as well if necessary. Today's meeting is taking place in a hybrid format. We have committee members on Zoom and in person. So now I want to welcome our witness for today from the Office of the Director of Public Prosecution, Georges Dolhaj, Deputy Director of Public Prosecutions. And as is the norm with this committee, we welcome you here and thank you for coming. And you have up to 5 minutes for your opening remarks.
Thank you very much. C'est un plaisir de rencontrer.
It's a pleasure to meet the committee today and discuss my candidacy for the position of Director of Public Prosecutions. I would like to thank the Attorney General and the Selection Committee for the confidence that they have shown in me by forwarding my candidacy today.
In democracy that rests on unceded and unsurrendered territory of the Anishinaabe Algonquin Nation, and commit to continue on the journey of reconciliation as a matter of profound respect and thanks for the care the First Nations, Métis, and Inuit have bestowed on the lands in which we all live together in Canada, and make a commitment to seek to do what I can, if you give me that opportunity, to contribute to a system of criminal justice built upon a just relationship with the Indigenous peoples of Canada. Allow me to say a few words about myself. I was born and raised in Hamilton, Ontario, where my mother and father had emigrated after being welcomed by Canada as refugees from the Hungarian Revolution in 1956. My parents came with nothing and instilled in my sister and myself the importance of the duty to work hard, the value of family, and the obligation always to help and respect others. I attended McMaster University and then the law school at the University of Western Ontario, where I worked at the Student Legal Clinic, and soon came to learn that law exists to help people, ordinary people, trying to make do, and not for the lawyers who are helping them. After practicing civil litigation on Bay Street, I attended the University of Cambridge and completed an LLM and determined that my heart was in the criminal law. I was offered a job as a prosecutor in the Department of Justice. I loved and still love being a prosecutor, including jury trials and appeals before the Ontario Court of Appeal and the Supreme Court of Canada. When an opportunity arose to work in Ottawa for 5 months doing Supreme Court of Canada criminal coordination, my wife and 3-month-old daughter and I moved here. And during the next 30 years, my wife and I welcomed another daughter, and professionally I worked in the human rights law section, providing advice with respect to amendments to the criminal code and the application of the Canadian Charter of Rights and Freedoms, and helped draft 2 incarnations of the criminal organization legislation and the national security legislation that ultimately culminated in the Terrorism Act 2001 after the attacks of September 11th. When the PPSC was created, I joined as one of the 2 deputy directors and had the opportunity to create the foundations and practices of the new PPSC. Through my time as deputy director, I've been responsible for national security matters and have provided the consent in almost all the cases on behalf of the Attorney General to the 79 prosecutions that have been launched in respect of terrorism offenses and the 47 terrorism peace bonds, as well as overseeing the prosecutions that then ensued. J'ai toujours été très impliqué dans les questions.
I have always been very involved in financial matters and other management functions. I believe that this has given me solid preparation for the role of Director of Public Prosecutions and Deputy Attorney General of Canada. The role involving prosecution management is defined in the DPP Act. The responsibility for functioning of the PPSC is the responsibility of the DPP, who manages prosecution services on the authority of and on behalf of the Attorney General. The DPP must have a solid understanding of criminal law and ensure that the organization fulfill its obligations towards the Attorney General and the people of Canada.
As provided by the DPP Act, the DPP needs to be able to provide clear guidelines to prosecutors regarding their exercise of discretion and allow the Attorney General to be notified of prosecutions that raise issues of general interest in sufficient time for him or her to react if they choose. The exception to this, of course, is with respect to the Canada Elections Act. En tant que sous-procureur général, le DPP doit également être.
In this role, the DPP has to be a good ambassador and play an important role of outreach with its provincial colleagues and other actors in the Canadian justice system and abroad. As a general manager and administrator of the service, the DPP has a very important role to play in managing the PPSC responsibly from a financial point of view, while ensuring the well-being of the employees of the PPSC.
In service, I'm privileged to work with people who are dedicated, fair, and ethical. These include the persons undertaking vital administrative tasks, such as arranging court dates and preparing disclosure to send to the accused, Crown Witness coordinators in the North who support victims of violence as they try to navigate the court process, and paralegals, as well as prosecutors and those in corporate services. I believe I can fulfill the functions of the DPP and look forward to the opportunity, should you permit me, to support and lead everyone who works in the prosecution service as they do their part to help keep Canadians safe and uphold the rule of law and constitutional protections. Thank you.
Merci beaucoup. Thank you. We will, per norm, go for the 6-minute round, and we will commence with Mr. Moore.
Okay, thank you, Madam Chair, and congratulations, sir, on your nomination and for your appearance before the committee today. I was pleased to be part of a government that created the public prosecution service and the role of director. And it's been interesting to watch the evolution of that organization. A few, I only have 6 minutes, so I'm going to try and ask my questions kind of tightly and hopefully get a tight response. But the role of the public prosecution service in prosecutions under the Controlled Drugs and Substances Act. My understanding is the service is responsible for prosecutions under the Act in all provinces, territories except Quebec and in New Brunswick when the RCMP is the police jurisdiction. Is that correct?
That's correct. In Quebec, we also prosecute when the RCMP is in their federal capacity are the police force, but otherwise, all other police forces theirs are prosecuted by the province.
Okay, so in August 2020, the Director of Public Prosecutions issued a directive to prosecutors when dealing with possession cases of the Controlled Drugs and Substances Act, which essentially was not to prosecute possession cases unless it was the most serious case and cases involved a public safety concern. What impact, if any, would that directive have had on those jurisdictions? Were we behind those other jurisdictions of Quebec and New Brunswick, or would they have followed suit from that directive?
Each of those jurisdictions has their own policies and guidance with respect to that, and they determine what is appropriate for themselves. Ours was one that was crafted specifically with consultations, among others, with the Provincial Prosecution Services, but also Health Canada, the police, the Canadian Chief of Police were directly consulted and supportive, as were other care professionals involved. But I know that Quebec and New Brunswick have slightly different policies.
Okay. I mean, as you know, we're dealing with an opioid crisis right now. Deaths, overdoses have skyrocketed. Organized crime is involved at every level, of course. And there's been legislation that has allowed, for example, where there used to be mandatory jail time for production, importing, exporting of Schedule I drugs, for example. Under Bill C-5, there's no longer a mandatory sentence for those charges. On the issue of possession, can you illustrate maybe if there is such a thing as a typical case where a charge would be brought now that we're a few years post that directive? What type of drug particularly, and then what type of scenario, if you could give one, where you would expect that a charge would be brought?
Absolutely. The guideline is very specific to our prosecutors, and although some people have interpreted it as a don't prosecute unless, it's very clear that it places directly the public safety question first and foremost, but recognizes that there's an enormous health component to this question. The sorts of scenarios that it contemplates specifically and that I can give as examples would be ones, for example, where youth are targeted or used as part of the possession, where persons who are in positions of trust, for example, persons who might be in an institution like a prison, are involved, where firearms are involved, or small communities, specifically recognizes that it's not a one-size-fits-all situation. There are small communities that for whom any drug coming in and in which possession is involved needs to be prosecuted in order to allow that community to exercise its ability to stem a tide or prevent it from coming. So it recognizes that there are a number of situations where prosecution of simple possession is still very appropriate. We've moved from 10,000 files down to 3,000 files. So we still do simple possession prosecutions in this country as a prosecution service. But we do it when one of those circumstances is involved.
Thank you, sir. And acknowledging now that cannabis and marijuana possession, those charges are largely a thing of a past. What type of drugs would typically what would be the top three where in cases where charges for possession are being laid?
Fentanyl, methamphetamine, benzodiazepines. Cocaine is always associated with those as well, unfortunately. Cocaine is being laced with benzos and fentanyls, and having the combination of all of those is a terrible, terrible combination. But those are typical drugs.
Do I have any time? Time is up. Your sign says, okay, that answers my question. Thank you, sir.
Thank you to you, Mr. Moore. Thank you, Mr. Dolhai. We will now go to 6 minutes, up to 6 minutes to Mr. Mendocino.
Thank you, Madam Chair. Mr. Dolhai, congratulations on your nomination. You have had a distinguished career underpinned by the values, in your own words, of hard work, but also a real commitment to the law, which is a vehicle to serve people, including to protect our communities. I listened very carefully to the outline of your own journey through the PPSC, having started at its inception, taking on a senior role, contributing to the drafting of national security legislation in what became ultimately the Anti-Terrorism Act, and overseeing prosecutions, including one in which I was involved in the Toronto 18. And I raised that case because it was a seminal case. It was a case that involved a conspiracy around a self-radicalized domestic terror cell, And it implicated a number of different agencies, not only the PPSC and conventional law enforcement, but equally intelligence agencies. And I raise this in the current climate because one of the important debates that's occurring right now is how we use intelligence and convert intelligence into admissible evidence for the purposes of prosecuting individuals who have been charged under national security provisions. And so, having had the benefit to see Bill C-70 and understanding that it is currently making its way through Parliament, I wonder if you can, in your own extensive experience, shed some light on how we can improve the protocols around taking intelligence and converting it into evidence for the purposes of prosecuting individuals who are charged under national security provisions.
Thank you. The issue of intelligence and evidence is one that's been at the forefront for a long time. It's a very complicated one, and as the National Security Intelligence Committee of Parliamentarians recognized in their recent report, it has its own requirements for study and consideration. I can speak to the operational cooperation that exists and the efforts that are made. And over the last number of years, significant efforts have been made by the RCMP and CSIS and other members of the intelligence community to do everything possible to ensure that materials that are relevant to a possible threat to the security of the country, to safety of individuals, to our well-being and our institutions, is shared in a timely fashion, and is shared in a way that's very clear, so that it's something that the police, when they receive it, they know what they can do with it and what they can't do with it. And that's a significant element, because oftentimes in the past there have been circumstances where the two institutions work so closely, but they have such different focuses and mandates that the question of when and what it can be used for require clarification, and that's come.
And those protocols will be strengthened, in my opinion, by Bill C-70. I want to focus on Part 2 to Bill C-70, which would amend the Security of Information Act to, among other things, create a number of new offenses. The first of which would be to create an indictable offense where, at the direction of or for the benefit of or in association with the foreign entity, there would be some elements of foreign interference, knowingly engaging in surreptitious or deceptive conduct at the direction of, for the benefit of, or in association with the foreign entity for a purpose that is prejudicial to the safety or interests of the state, or being reckless as to whether the conduct is likely to harm Canadian interests, and engaging in surreptitious or deceptive conduct at the direction of or in association with a foreign entity with the intent to influence, among other things, the exercise of a democratic right in Canada. I've summarized those offenses. Do you believe, Mr. Dolhaj, that those additional provisions will help to provide additional tools to law enforcement, including the PPSC, for the purposes of protecting our national security?
The question of particular legislation before Parliament is not one I can really comment upon. What I can comment upon is that the issues of foreign interference and foreign directed activities has become much more predominant within the national security files that I see, and that it's an area that continues to evolve and becomes much more challenging all the time in prosecuting. And whatever Parliament passes, we will certainly apply and pursue with the police and assist them in ensuring that they can gather evidence.
Is it safe to say that this will be a priority for the PPSC going forward, namely to ensure that our institutions, specifically our democratic institutions, are safe from foreign interference?
Absolutely, it's a priority. In the national security realm, there are two areas of priority that are overwhelming. That one and the absolute blossoming, and I don't mean that in a positive way, and it's a terrible way, of extremist ideologies that are using the internet in a way to recruit and activate persons across the country.
In my
hate.
brief remaining time, this committee recently concluded, or is in the process of concluding and drafting a study to combat anti-Semitism. A number of Canadians, Jewish Canadians, came forward and expressed concerns about the absence of the prosecution of anti-Semitic hate crime. Are you committed to ensuring that prosecutors have the training that is necessary and to removing any unnecessary barriers to ensure the prosecution of anti-Semitic hate crime and hate crime generally to protect communities?
Time's up. Brief-
Hate crime is something that provinces do, but certainly we work with them in cooperation, and that's a
Thank you.
commitment that I'd make.
Thank you very much. We will now go to Monsieur Fortin pour 6 minutes, s'il vous plaît. La parole est à vous. Merci.
6 minutes, you have the floor. Thank you, Chair. Mr. Dye, thank you for being here today. I would like to continue along the lines of my colleague, Mr. Mendicino. We have heard in recent weeks from people coming to discuss the issue of anti-Semitism in Canada. We've heard people who came to us talking about the issue of Islamophobia. And had we wished to continue, I'm sure we would have been able to hear about all kinds of situations involving hate. This is a problem that we must deal with. Again, this week, the RCMP was saying that it is confronted with an increase in hate crimes in Canada and is wondering whether it has the necessary tools to deal with this crisis. I'd like to hear what you have to say about this. In your opinion, I understand that you have experience at the PP, at the SDPP. Right now, does the DPP have, or does the PPSC have, the tools necessary to combat the increase in hatred, or the necessary tools to deal with what's needed? I understand that I mix up the names. Sometimes I refer to the Quebec version, but I'm referring here to the Canadian version. Thank you. There are many tools now in the criminal code to address terrorism-related crimes, particularly crimes involving a way of carrying out the goal of practicing terrorism using hatred. There are several prosecutions now where one key element is the use by individuals of the internet to increase or create an atmosphere of hate, particularly in the area of Islamophobia and anti-Semitism. This is a situation in which the criminal code now allows the service to deal with this problem. The problem has increased significantly across Canada. Recently, the Ontario prosecution regarding the Afsar family in just a few words, as you know, we don't have much time here. But one of the questions that keeps coming to my mind regarding hate crimes is the definition of hate. There is a proposal in a draft bill. We'll be seeing what we do with it in the committee. But in a few words, could you give me the definition that appears to you to be the most appropriate of what constitutes hate? Or if you can't do so, perhaps you could indicate whether there's a way in which we could improve our understanding and our definition of hatred in the criminal code. Hate crimes are under provincial responsibility for the provincial prosecution services. In the context of the Terrorism Act, we focus on questions of ideology using hate. Often, this ideology seeks to identify an other, a person or a group, or a belief involving people that the ideology wishes to exclude from Canadian society, and that it seeks to attack at the same time. But it depends on the ideology. Currently, Section 319 of the Criminal Code, which prohibits fomenting anti-Semitism or hate, includes exceptions. It says that reasonable defense would be if the accused of one of these crimes is based on a religious text. I'm summing up in my own words. Do you have an opinion about that matter? Is this good or not to have this kind of provision in the criminal code allowing one to commit hate crimes if one is basing oneself on a sincere religious belief? I cannot offer a point of view on a bill that's before Parliament, particularly in a context in which the other prosecution services must lead the prosecutions. Thank you. I don't know how much time I have left, perhaps a minute or two. What about your experience in Quebec? Can you tell us a few words or your memories, good or bad, about your experience in Quebec files? My experience with Quebec matters. In what context? Do you mean drugs, national security? Well, where the federal government intervened. My experience was marvelous with the Quebec DPSP and the regional director. It was excellent. Excellent. Thank you very much. Thank you. Now over to Madame Blaney for 6 minutes.
Well, thank you, Chair, and I want to congratulate you on your nomination and apologize. I'm allergic to this room, so I have an interesting dust allergy in Ontario, which is fun. But I think, you know, I heard a lot of what you were saying earlier in response to some of the members that have already asked questions. And the committee is currently concluding its study on the rise of anti-Semitism and Islamophobia in Canada. And we all know the outcomes have been incredibly painful. Can you please comment on the low levels of successful prosecutions for hate crimes and whether this is a problem with the laws that Canada currently has, or are there other causes that are impeding successful prosecutions?
Respectfully, I'm not able to comment on the prosecutions that are conducted by the provincial prosecution services, which are the ones that conduct them, except in the north where we conduct them, and we have not had hate crime prosecutions in the Northern Territories.
Well, thank you. I do have a question as well. We just passed with third reading in the House of Commons Bill C-332, and now it's on its way to the Senate. So once this bill is passed, it will make coercive and controlling behavior a criminal offense. As the new National Director for Public Prosecutions, what actions will you be taking to prepare the prosecution service to handle these new cases?
As with any changes in the law, we will be providing training to our folks, but I must say that in the area of intimate partner violence, it's a priority for us. In the north, we have taken steps already, and this will be part and parcel of those steps to augment the capacity we have in order to provide greater support to the victims through the Crown Witness Coordinators, but also to provide a continuity of prosecutors so that they're dealing with the same people as they're going along. I mean, what is an incredibly traumatic and an incredibly foreign type of process for any Canadian to be going through, but also especially when they're going through it in respect of something as personal and as hurtful and as traumatic as intimate partner violence. So we have specialized teams that we've formed as well to review and consider what we are doing and what we should do differently in these cases. And if the legislation is passed, we will certainly focus upon it.
So, in the process of that, because when we talk to people who have gone through these experiences, and of course, before they couldn't sort of trigger this coercive controlling behavior as a criminal offense, and that's what we're hoping to see fundamentally change. You talked about training and work that you've done already. Could you sort of indicate to us what the best practices are and what you think would be the initial steps moving forward? Because, of course, the concern is always building trust so that people feel that when they come forward that the process will be followed. So I'm just wondering, in terms of building those relationships, what were the best practices?
Our first and best practice was the creation of the Crown Witness Coordinators, because having persons who are not lawyers, whose only function, and it's a critical function, is to focus on those witnesses, to be the person that they reach out to, that the person who they can ask whatever question with, who will be with them as they're going through the process, only to be with them for that purpose, not for purposes of particularly structuring the evidence and doing other things, but in order to support them. That's probably our best practice that we've initiated. But in addition, we've done training, and there's more training to do around understanding the dynamics that arise here. The area of violence against women continues to be an area where there seems to be some reluctance in various quarters, and that can also occur in any organization as well, due to a lack of understanding of what those dynamics are and how they play out. I'm very pleased to say that one of the prosecutions that we undertook was a national security prosecution, but went directly to this issue, was the prosecution in Toronto, where there was an attack on persons who worked in a setting providing massage services, where they were brutally attacked and murdered, and attempted murder by a person who was motivated by the incel ideology, an ideology that's directly focused on women as the targets. And the recognition of that being an ideology was critical.
And so just to follow up with that, because I know in my work previous to this, I worked with newcomer women, and I found them particularly vulnerable, along with Indigenous women. So I'm wondering, in terms of the work that you have done, what are the key things that you will take in terms of reflecting on training, on working in terms of addressing the needs of those particular groups of women?
The extent to which we can draw upon the experience of those who have dealt with those persons as witnesses, but also allow the voices of those who've gone through the system and are prepared to speak to us, to be heard by our prosecutors, is a key element. Because I think until you hear a story being told in terms of what was experienced and all the reluctance and all of the pressures that came to bear, whether they're family or societal, in terms of coming forward, it's not as real. And you need to make it real to people. The first time I remember a person who was testifying told me that when she was testifying about a very traumatic attack on her, she focused on a crack in the table, because that was her focus. That was what was going to get her through what was a terribly traumatic experience in recounting what had happened.
Thank you.
So it's doing that.
Thank you very much. We will now go to our second round with 5 minutes to Mr. Van Popta, please.
Thank you, Madam Chair, and thank you, Mr. Delay, for being with us here today, and congratulations on your nomination, soon-to-be appointment. I understand that this is the last hurdle, or perhaps second to last hurdle for you to overcome. So congratulations. Job well done so far. I'm going to follow up on a question that my colleague, Mr. Moore, asked about decriminalization of possession of small amounts of illicit drugs. And I want to focus particularly on what happened in my home province of British Columbia with the pilot project with the federal government giving an exemption to British Columbia under the Controlled Drugs and Substances Act. It's a 3-year pilot project. But a year into it, it was clear that it was a failed project, and it's been rolled back substantially now. Again, the province and the federal government working together. So I wonder if you could elaborate on that, because prior to that, I understand that there was de facto decriminalization in any event, not only in British Columbia, but across the country. for possession of small amounts for personal use. So what big difference did the exemption order make? And now that it's been rolled back, what are prosecutions going to look like going forward?
Thank you for the question. There is a perception that that there was a decriminalization, in fact, of a simple possession. But as I indicated, I think the statistics bear out differently. That in fact we continue to prosecute simple possessions across the country, as did Quebec and New Brunswick, but only in those circumstances where one of the other complicating factors were present, the things that affected public safety, one of in British Columbia in particular, however, there was very few of those prosecutions that went forward. There were few of those instances that were brought to us where there were those public safety elements. With the change in the exemption, I think the primary effect will be affecting what police can and can't do with respect to their interventions. Then their decisions as to whether or not that translates into a prosecution is another matter, but they will be in a position, I think, to be able to have interventions in a different way than they were while the exemption was in place. And in many ways, they are the organization that is on the front lines. They are the one with the biggest footprint with respect to dealing with the persons who are subject to these substance use disorders. But whether that translates into prosecutions, I don't know, because again, there are many avenues to address the underlying problem, and we've had tremendous success with respect to many of them, including such things as drug treatment courts. So it will depend on the police and their decisions as to what they refer.
But it also depends on your office, doesn't it? You have said that you give clear directions to prosecutors about how prosecutions are to be undertaken or which cases even are to be prosecuted. So to what extent does the prosecution office in British Columbia rely on directions from your office?
I would like to think they rely entirely on them because no person and no prosecutor, no matter how well intentioned, is their own determinant. We're all persons who have a responsibility to others and report to others, and ultimately, as DPP, I would report to the Attorney General. But there is scope for local practice, and both within larger and smaller communities, and from province to province.
So I'd like to ask you. You said you report to the Attorney General. You had written recently about the Shawcross principle and the rule of law. Central to these principles, of course, is the independence of the prosecution service. Given that in Canada, the Minister of Justice and the Attorney General is one and the same person, how does that affect prosecutorial independence?
Them being in one and the same person, in my experience, has never affected prosecutorial independence. I've had the pleasure of dealing with a number of attorneys general since we were created, and I have never found that there has been an issue with respect to the manner in which they approach the attorney general function. They're scrupulous in the way they approach it. All of them have been.
My understanding is that in the United Kingdom, those two roles might be separated. I don't know if that's always the case, or
They are separated there, but the McClellan report looked at that issue and concluded that what we had in Canada was something that was functioning well. And again, in my experience, every Attorney General has respected the independence of the prosecution service entirely and scrupulously.
Do I still have time for one quick question? You do. Okay, good. So you had mentioned the London family case.
I was giving you 6 minutes.
Well, thank you very
Go
much
ahead,
for that.
ask your question. And
Okay,
then maybe
I'll keep it very quick then. The Asfeld family case, the person was charged and convicted of 4 cases of murder, but also terrorism acts. Although in the Quebec City mosque killing, the terrorism charges were not laid. And I wonder what the difference would be, and if you could give your sort of academic opinion on that.
The difference, in short, is that the difference is evidence. Each case has its own evidence. And in each case, you have to assess the evidence to determine whether, based on the admissible evidence, you can meet the beyond a reasonable doubt standard. And that's the difference between the two cases. That's
Thank
the only
you.
difference between the two
Thank
cases.
you very much. So, fabulous, thank you. And let me do the same now with the others. I'll just increase them slightly. So, Mr. Housefather, if you wish, 6 minutes.
Okay, thank you, Madam Chair. I hopefully will be able to do it in 5. Mr. Dolhai, congratulations on your nomination. The PSPC is responsible for providing prosecution-related advice to law enforcement agencies across the country. Can you explain how you, if you assume this role, will do that? How will you change what the department does today? What would you do to improve that service?
Well, part of what that service is providing a window in for the police services on how we would deal with a case if it comes to us. And when we provide them with advice during the course of an investigation, we're not providing them with advice as their lawyers per se. We're providing them with advice about, if you do it in this way, this is how that will translate into admissible evidence. What I would do is I would increase what we are already doing with respect to training. There's a lot more training that could be done. We would seek to work with the RCMP to determine if there are avenues where we could provide additional training to new officers, for example, at depot. Also, with respect to the police of local jurisdiction, there is one of the things that occurs is that there is a relationship that we have across the country with all of the local police forces, and we have to adapt to their particular needs and their focuses as far as being able to assist them both in terms of the mechanics of those operations, but also in terms of providing them with that training and timely advice. One of the things I would do as well is I would canvass with the chiefs of police with respect to what do they think of the service that we're providing. We are in that respect, like anyone else, someone who is subject to feedback, and by those who we're attempting to work with and assist. And one of the things to do is to find out directly from the source.
Agreed. Just a brief answer to this one. Do you also work with the provincial prosecution services in terms of coordinating responses and ensuring that you have a uniform standard of approach across the country?
We do. We have a heads of prosecution committee where all of the heads of prosecution meet twice a year, and it's a committee where everyone just rolls up their sleeves and puts all issues of politics aside and just focuses on what's the best way to deal with the challenges we're collectively facing. But then on individual cases, we also cooperate, and we have arrangements with each one of the provinces, various forms of arrangements, whereby we will also determine on major-minor basis who does the prosecution. Is it both of us? Is it one of us that leads if we have the more important charges, significant charges, or is it something that they do? And we also consult extensively with respect to issues relating to how best to deal with extremist violence.
So that leads me then to a question that Mr. Mendicino had brought up, and then Mr. Fortin brought up, which is how we're dealing with anti-Semitic hate in this country and other forms of hate, such as Islamophobia. And I want to refer you to recent statements by Adil Sharkawi, where Mr. Sharkawi in Montreal on October the 28th of last year made a speech in Arabic where he said, Allah, take care of these Zionist aggressors. Allah, take care of the enemies of the people of Gaza. Allah, identify them all, then exterminate them, and don't spare any of them. And the Quebec Prosecution Service, the DPCP, determined that there wasn't sufficient evidence to reveal the commission of a criminal offense under, I presume, sections 318 and 319 of the Criminal Code. Mr. Dolhai, would your office have in any way been involved in offering advice on an issue like that, or will this be an issue in terms of the way that we prosecute 318 and 319 offenses that you would undertake would be part of the next discussions with the provinces when you have future rounds of meetings?
I can't comment, Mr. Hausfelder, I can't comment on any particular case or any particular situation and what consultations were or weren't had, because those would also raise issues with respect to what was or wasn't referred to us by the police. But certainly, I expect that one of the things that will be front and center in our discussions at our next heads of prosecution meeting, if I were to be there co-chairing that, would be the question of how we cooperate and coordinate around issues as to how to deal with the hate crimes and how we ensure that there is no light left between the criminal code provisions and the terrorism provisions, as far as ensuring that there is that circumstances meriting prosecution are dealt with.
Thank you. I want to give you the opportunity to talk about your vision for the office. I asked you about it in the light of training and consultation with police services across the country. But what is your large vision for the office? How would you, and I understand that you've been there for a while, but Ms. Roussel has been, theoretically director, and not you. What would you do, without in any way diminishing all the important work she's done, what would you do to put your own stamp on things? What would you do to change the office in any way?
What I would do is...
So let's leave that response. Perhaps you might get asked, just because I did give 6 minutes. So I'm now going to go to the final 3 minutes and 3 minutes and conclude. So, Mr. Fortin, je vous donne 30 secondes plus.
Mr. Fortin, you have another 30 seconds. Thank you, Chair. Mr. Dole, I don't have much time. I'd like to hear what you have to say about your vision of the relationship that the director of public prosecution should have. I know that often there's a separation between the two, but how do you see your relationship with the Attorney General, Department of Justice, in your future functions? The relationship is one of mutual respect between the two individuals. The director manages the service, and that includes decisions regarding prosecutions, individual prosecutions, as well as guidelines for prosecutions. However, it is extremely important to ensure that the Attorney General is always informed regarding important matters, so as to enable the Attorney General to indicate a direction, should that be the case. But it's always done publicly, not confidentially. That doesn't exist. Communication is always from the Attorney General to the Director of Public Prosecutions regarding a prosecution or a category of prosecutions. It's always public to allow Canadians to know what is going on. And how would you describe the reverse relationship? In other words, from your service to the Minister, to the Department of Justice, the Attorney General, do you see any possibilities of suggesting any legislative amendments? How do you see that relationship going in the other direction, from your department to the Attorney General and Minister of Justice? I do not have any suggestions at this time. Well, given the assumption that I raised earlier, I'm not saying that that's the case, but if you were to conclude that you didn't have the necessary tools to be able to prosecute in certain problematic instances, how would you proceed to inform the department, the Minister of Justice, of this? I would prepare information concerning the impacts of the particular prosecution and in general. And it's always the case, we must indicate to the court the reason for which we are not proceeding. You're talking about doing this in public or private?
3 minutes, up to Madame Blaney, s'il vous plaît.
Well, thank you so much, Chair. And I really just have one more question for you, so hopefully we'll be able to wrap this up. And thank you again for being here. I am curious, I know resources can sometimes be a challenge, so I'm just wondering if you could inform the committee on whether or not the prosecution service has adequate resources to ensure timely and accessible justice in the 3 territories where you are responsible for criminal prosecutions, and how you deal with that challenge if you don't have the resources.
We have resources that were allocated to us that allowed us to increase by 25% our capacity in the 3 northern territories. And that has provided significant assistance to us to ensure that continuity that I spoke about, both with respect to Crown Witness coordinators as well as prosecutors, and allowed us to have those focused initiatives that we have undertaken with respect to the prosecution of violence, especially sexual violence cases, as well as to undertake a number of innovative programs to incorporate, in Nunavut in particular, traditional Inuit justice concepts. We have a pilot right now that we are launching in 3 communities where we will be involving elders throughout the consultation process and consideration process directly with us, and very excited about it, actually.
Okay, now I have a follow-up on that. You talked about the work you're doing in Nunavut specifically, and in the beginning of your intervention with us, you talked about the meaningfulness of reconciliation and the work that you are doing. I'm just wondering, in this role, how would that influence the work that you do, knowing that, of course, Indigenous people are largely overrepresented in so many areas for many complex and important reasons that have not been challenged in the way I would like to see them challenged. I'm just wondering, what will you bring to the table in terms of those skill sets?
What I'll bring to the table is we'll build on what we've done, which is we've done training with respect to Indigenous issues across all of our regional offices, but one, it's been completed. We've done over 14 or 15 sessions. There are 4 modules, very, very comprehensive, that go from history to individual trauma and how you deal with trauma to preparing GLADU reports. But specifically beyond that, it is it seems an intractable problem of overrepresentation. And I am of the view that we need to consider whether or not we need to provide even further specific guidance to our prosecutors as to how they approach it, because we cannot have year over year the same statistics being presented. It is not a question of good intentions. It has to be a question of results. And part of what the tools that I have are to determine whether or not we need to be even more directive with respect to what our expectations are.
Thank you.
Thank you very much. This concludes the questions from our colleagues, members of Parliament. Mr. Dohai, thank you very much for appearing before us. You have a wealth of experience at the Public Prosecution Service Canada. As a former Justice Minister in Nova Scotia myself, I appreciated the questions and your response with respect to the importance of your relationship with the Attorney General and the independents, also the relationship that you would have with the provinces and territories, and as far the training that is offered in the communications. So allow me, committee, now to ask you, is it agreed that we report to the House that the committee is in agreement with the proposed nomination of Mr. George Dolhaj? Thank you very much, and congratulations. I will now suspend for a few minutes in order to excuse our witness, and we will continue in camera for our drafting instructions to our analyst. Suspended.